Okay, thank you. So members, I declare the meeting now open to the public online. I'd like to welcome all of our members who are participating by video conferencing today. And I would like to remind members about the protocols regarding the use of electronic devices. So apologies there, members. Clerk, are you aware of any apologies?
Chair, just to say that Deborah's let me know she'll be a wee bit late today, but hopes to be here by about 12:30 or so.
Okay, and any other members aware of any apologies? No, thank you. Okay, members, so we're moving on then to our first substantive briefing session today, and this is in relation to the Abortion Services Safe Access Zone Bill, and we are today receiving evidence from the PSNI. So we're going to continue the scrutiny of this bill via this afternoon's briefing. Do any members wish to declare an interest? No, thank you. Members, then I will move to the written. I'll refer you to the written submission received from the PSNA at tab 2.1 and of the pack, and copies of the bill and EFM at tabs 2.2 and 2.3. So I'd now like to welcome Chief Superintendent Melanie Jones, who's Head of Criminal Justice in the Community Safety Department in the PSNA. Melanie, are you able to hear us there okay?
Yes, I am, thank you. Can you hear me okay?
Hearing you fine. Your visual's a bit blurry there, but maybe that's just my system here. Maybe it's okay, but your voice is coming across clearly enough, and that's the most important thing. We can see you as well. It's just it doesn't seem to be great quality on the video camera. Melanie, will you please go ahead and give us your briefing, and then maybe we could take some questions from members. Thank you.
Certainly, yes. Like many legislation of this kind of nature, there is a real importance around balancing of human rights. In particular, I would like to highlight to the committee the key components of human rights that would come into play here. So Article 7, right to respect private and family life, which will particularly apply to people who work at such establishments and people who are using the services and accessing services of establishments, as against opposed to the groups that may seek to gather and protest around the establishments, where Article 8, 9 and 10, which are the usual articles that we see exercised by those engaging in protest. So right to freedom of thought, conscience and religion, freedom of expression and opinions, and freedom of assembly will be the key human rights that would come into play in any such legislation being granted. Looking at the draft legislation, and I'll refer to the letter that I provided in response, specifically in relation to the legislation, I would highlight the potential implications of the Dolan ruling in England and Wales, although not identical, does have some similarities in reference to what the challenge was, which was around what was tantamount to a blanket ban against assembly. So there are potentially some considerations for the committee and the legislator around the specifics that are contained within the draft bill of preventing any activity of seeking to influence people within the protected or safe zone. So that could arguably be interpreted as a blanket right ban on assembly and protest. So there is potentially consideration there for the legislator to make sure that that would not be the case. Just moving on, it was difficult for me to give any commentary around the exact definition and the location of any safe zone because there was a lack of clarity in the bill. Clearly, the operational outworkings usually of any protest, counter-protests, is around giving a zone which would satisfy human rights, which quite often can be within line of sight. But without that clarity around the safe zone, it was difficult for me to make exact commentary on that. But I would say that sometimes a safe zone or an exclusion zone can bring around it challenges. I was asked to provide an additional response in relation to my commentary towards the end of the letter around the overriding health considerations, and I put health in inverted commas, just to give clarity to the committee. That was really just to give the broadest possible interpretation to the word health, and the fact that different groups and campaigning groups would have a different priority around health of the unborn child, health of the expectant mother, and not forgetting, of course, health and well-being of people who are employed at clinics and places offering such services. And then just lastly from me, there were a couple of what I thought were potential loopholes in the proposed bill that was provided to me. So in paragraph number 6, clause 6, the defence, it's very difficult to be able to disprove a lack of knowledge on behalf of the protesters. So we would only realistically be able to take enforcement action against repeat offenders where we could demonstrate beyond reasonable doubt that the protester or the person present knew that they were inside the safe zone, and that would probably require us to be able to record and document warnings in relation to it, which does mean then that the activity of them being there would have to be tolerated for some time, which could have an adverse impact on persons who were attending the place, either to access treatment or to work there. And then in clause 7 around the enforcement, my observation would be that within the enforcement there doesn't appear to be any requirement for those who are removed from the safe zone to provide their personal details to the police. And again, that provides a difficulty if people are to re-enter that safe zone and continue in the same conduct, that then they could potentially rely on a defence as provided in clause 6, lack of knowledge, unless it happens to be the same officers at the same place and time. So it would be helpful around enforcement to provide a requirement to provide personal details at a time when they're either asked to leave or forced to leave the safe zone. And then lastly, around enforcement, there is no specific power of seizure in relation to recording equipment. There is the power to ask and instruct persons present not to film, but there's no specific power to seize the equipment. And while provisions under the Police and Criminal Evidence Order will be adequate for a criminal investigation, it would not be effective to prevent further offending if persons then re-entered the safe zone and continued with the same behaviours. So that was my observations in relation to the complexities of it. And then just to highlight, as with all legislation, it would be remiss of me not to talk about the resourcing implications for the police to enforce this. So protests of this nature can be frequent and spontaneous and can be elongated. And effective policing would probably require a continuous police presence for the duration of any such activity, both to ensure that we have the monitoring and the evidence gathering in place and we understand who is moving in and out of the safe zone and potentially committing offences, to prevent a breach of the peace, and also to provide a reassurance for those working on accessing services at such places. So that was really the summary. I have also looked at what other policing powers might be applicable if the committee thought that might be helpful.
We'll leave that to one side for now, unless members seek that information. Maybe that could even be sent through to us, Melanie. I'll move on to questions just now from members, and I suppose firstly from myself, a few from myself. And you've mentioned there about the lack of clarity in relation to the safe zone and size and how those will be structured. What would your advice be in relation to how those could be assessed and set up from a policing perspective?
Yeah, I think my advice would be careful consideration around the competing human rights at play and making sure that any designated safe zones had been carefully balanced against those individual rights that would be exercised. So generally speaking, when we use sort of similar powers around Article 4.2 of the Public Order Act, where we designate places that people can assemble and make views held, we try to do it in a way that upholds their rights around Articles 8, 9 and 10. And generally speaking, that would be, where possible, within line of sight of whatever they are expressing a view about. But of course, this the impact on the people either working at these centres or accessing the services have to be carefully considered in terms of the line of sight, and the fact that line of sight may actually mean that their conduct is more intimidating and deters people from accessing the services. So it's around the careful consideration of what upholds the individual rights and would be least likely to bring the application of the safe zone into conflict or challenge legally, with making sure that it has the net effect of making a safe space for people to access work or services.
Sorry, I think Colin might have froze there.
Sorry, I thought it was me that had frozen for a moment.
No.
Right, I thought, oh, I've said all that and I've frozen.
Sorry, Melanie, we'll just try and get him back on again.
It's fine, it's fine.
Just take a wee second.
Am I back online now, Keith?
Yes, I can hear you.
Yeah,
Okay.
So listen, I don't know what happened there, Melanie. I got everything. I certainly got everything right up to the end of yours. I haven't had any trouble with broadband earlier today, so I'm not sure what happened there. Hopefully it'll not happen again. But so I was just going to follow up then around some of the specific details you have highlighted, and I think very usefully highlighted, around the providing of details, for example, to the police, and the specific part of procedure which may be missing from the bill. So can I ask, in relation to those, has there been any ongoing liaison between yourselves and, first of all, the Department of Health around the bill?
No, other than I was asked to provide the letter which you have a copy of. So as part, that would be a routine from any new legislation, that the PSNI would generally be asked to provide commentary around the draft legislation that was proposed, and that's the nature and extent of any involvement that we've had. Okay,
and that may answer my next one. Is, has there been any contact then with the proposer of the sponsor of the bill?
Not with me, and not to my knowledge with the PSNI at all.
Okay, and this one I think is slightly different and slightly separate. Has there been any exploration by yourselves independently in relation to how this is operated and has operated outside of here? For example, I think it's currently operating in Scotland. Have you looked at other jurisdictions where similar legislation is in place to see what can be learned from that?
Yeah, the only place that I'm aware of is the Ealing case, which was fairly similar, and it was actually taken to judicial review, and the issue of the safe zone was found to be compliant with human rights and not denying a right to protest by the Court of Appeal. So the judicial review dismissed both of the appeals, holding that the safe zone was human rights compliant and did not take away a right to protest. So that's the only one that I am aware of, the Ealing case, which was 2020.
Okay, thank you. As it currently stands, do you have concerns around the enforcement, or do you feel that with some amendment, this is something that could be put in place in a way which doesn't challenge those Dolan issues that you have identified at the start of your presentation?
I have to be honest, I do think that enforcement will be subject to challenge, I've no doubt, particularly that fundamental to the right to protest is to try and influence other people. So the fact that this legislation restricts activity within the safe zone, and that activity would likely be things like handing out leaflets or holding placards, trying to influence choices and behaviours, will undoubtedly bring it into legal challenge. That said, I'm not saying that legal challenge would be neither successful nor unsuccessful, but I do think that there's a high likelihood that this would be challenged because of the very nature of the legislation. I think that would be unavoidable, and probably would be naive of me to say that it wouldn't be subject to challenge.
Okay, thanks, Melanie. I'm going to go to other committee members now, and I'm going to go and check, first of all, with Colin, because I know Colin has to leave for another committee for a period of time. So I'll just check with Colin McGrath if he wants to come in with a question at this stage or later on. Colin?
Okay at the minute, Chair. I'm fine, thank you. Thank you very much for that opportunity, though. Appreciate that.
Okay, so I know, and we do have indications then from Deputy Chair Pam Cameron, who I'm going to next, and then Carol E. Cullen, and then we'll see who else has questions then. So I'm going now to Pam. Go ahead, Pam, please.
Thank you, Chair, and thank you to Chief Superintendent Jones for her presentation. I did have to nip downstairs there. The dogs were kicking off the door, so I might have missed a little bit, but I do have some questions for you, if that's okay. And the first one was to ask what, if any, consultation you've had with the bill sponsor prior to the introduction of this bill. That's in terms of the PSNI or the Community Safety Department. That's the first question, please.
Yeah, I've had no contact at all, and I'm not aware of any contact into the PSNI other than the letter asking for PSNI opinion as to the draft bill.
Okay, that's great. And could you tell us about around the implementation of this bill as drafted? Would that result in more rather than fewer police officers being deployed to challenging public order situations in this area, in your opinion?
It would definitely increase the number of deployments, because I think realistically effective policing of the safe zones can only be done with a fairly static policing presence at them at times when there is either intelligence or information that there would be or may be some kind of gathering within the safe zone where offences might be committed, and those accessing services or working at the premises may be prevented, hindered or intimidated. So definitely would increase. At the present time, you know, we do spontaneously deploy, and sometimes we have information about planned activity around some of the establishments. I think there was one in the last couple of weeks. But with the implementation of the safe zone, there would be a need to make sure that that safe zone was effectively managed. And there may be opportunities to think about that within the bill around it not solely being a police role. Most of these gatherings are fairly compliant, so it may be that there could be some scope to mean that enforcement of the safe zone and establishment of it could fall to from something like street wardens or other statutory resources. That would be a matter for the legislators.
Okay, thank you. And I suppose following on from that, would you have an indication as to how many working hours on average are spent by police on incidents with relevance to the scope of the bill?
That's very difficult to say, because without knowing how many premises would have a designated safe zone, so how many premises would offer the services that would fall under the legislation and would then apply as part of the legislation to have a safe zone, that would be very, very difficult to say.
Okay, and I want to ask you, I know you have already touched on the influence issue there, but would you agree that the concept of influence, either directly or indirectly, is extremely broad and would inevitably see legitimate activities wrongly criminalised?
I would say that normally legitimate activities, yes, such as handing out leaflets, would potentially be criminalised when those activities are undertaken within a proposed safe zone and an identified safe zone, yes. So that's where I think the potential for this to come into conflict with the law and be challenged puts it much further up the scale than perhaps other legislation, because what would be a normally lawful activity would be a criminal activity if it was undertaken within the safe zone. But actually, the handing out of a leaflet, for instance, is something that is probably an inherently recognised part of public protest and campaigning to influence behaviours and decision making.
Okay, and so if such a concept was to make it onto the statute books, what mitigations would PSNI have to take to protect itself from that legal challenge?
I think the important thing is the efforts that we would need to go to in terms of the evidence gathering for any criminal case. So at the moment, the wording is quite bland around the activity, and what we would need to do is prove beyond reasonable doubt that there was an intention to intimidate rather than it being an intention to persuade. So it would clearly bring about an investigative requirement to present that evidence to the PPS in order to be able to successfully take cases through the courts.
Thank you for that. And probably the last one from me, Chair, at this point. Could I ask, are harassment laws working at present? And does the PSNI believe that amendment of that legislation would provide a more proportionate response to increasing concerns in this area?
The difficulty is here that under public order legislation and under harassment laws, it's well documented in case law that it cannot be construed as public order or harassment to hold a view and articulate a view that may be distasteful or may cause upset to some parts of society. So the difficulty with using that legislation is where that marker is. So what is distasteful and unpleasant to some people, to other people may be seen as harassing, alarming and distressing. But there is much case law to say that actually the threshold for that is quite high, and people must be able to demonstrate views which may be unpleasant or upsetting to others without breaking the law. And the other issue probably around this, which is slightly more nuanced, is that in order to reach that threshold for the police to be able to intervene and take action around harassment, that behaviour has to be tolerated for an amount of time, which then for something like a premises offering abortion services or information would mean that actually those persons engaging in that behaviour have achieved what they want to do by intimidating people not to attend the premises or not to attend work. So the fact that the behaviour would have to be tolerated for a time probably then takes away the effectiveness of actually not having it there in the first place. I hope that makes sense. A bit long-winded, but hopefully it makes sense.
Yes, that's very helpful. Do you think, just in finishing off with yourself, do you think that the harassment laws could be strengthened to be effective in these particular scenarios, to maybe mitigate against needing this type of legislation?
I think it's something that could be explored, but I think again, that potentially that would bump into rights under certainly Articles 8 and 9, that there is always a right to express views, even if they are not a popular view or a distasteful view to a large section of community, and that's an inherent right of freedom of speech. And it would be difficult to strengthen those laws to a point where I think that you would cross over into that territory and then mean that those laws would be probably subject to legal challenge as well. So difficult area. It would be each case on its merits. There are some behaviours which are quite clearly harassing, alarming or intimidating, but there is a scalar, and without restricting those rights to freedom of speech, you can quite easily, overstep the mark in strengthening the law.
Okay, thank you very much. Thanks, Chair.
Okay, thank you, Pam. And moving then to Carol Nichillen. Leanna Carol, leis do ceist.
Gurmagad Carly, Happy New Year, Mel. Long time no see. So, I mean, this is a fairly straightforward piece of legislation, as we thought. But certainly some of the complexities you've described are concerning, Mel, because what I've heard is that, like, even just listening to some of the things you've said, it almost means that someone needs to complain that they feel harassed or intimidated. Say, for example, in the past, the PSNI have intervened when people hoping to access the treatment were harassed getting out of their car, harassed walking to the entrance of the healthcare setting. The staff were then harassed leaving the person from the healthcare setting back to their car, and they did make complaints around the graphic nature of the material. But it had to be withstood for a certain period of time, and then the person had to complain. So I still think that needs to be tightened up, and I would hope that this legislation, if there's things, as Colm said, we're going to have the proposer of the bill. We're going to be talking to Claire later, but I would hope if there's things that we could do now to tighten this up, then we should, because we don't want any unintended consequences. But already, I mean, Articles 5, 8, 9, 13 and 14 are completely applicable here. And again, we talk about the competition rights, but what else can the PSNI do to ensure that, so for example, if, for example, someone was with an organisation and stood beside that organisation who didn't have a banner, okay, but were there, and were there after being warned and proceeded to remain there, but denied that they were members of that organisation, what would happen? You know, because at times we have 2 or 3 groups standing outside these healthcare settings, okay? So, you know, what do the PSNI envisage is their role if someone is prevented by either verbal abuse or handing out leaflets with graphic material of accessing health and social care?
Yeah, I think the important thing with that kind of scenario that you describe is that we use the full range of evidence gathering material, because as part of a presentation of any case to the Public Prosecution Service, we have to be able to show that there's a prima facie case that somebody has broken the law. So clearly this legislation does allow people to stand within any safe zone, provided they're not engaging in any of the activities specified in I think it's clause 5, where the offences are made out. Merely standing somewhere clearly is not an offence, and it would be for the PSNI to collate broader evidence to show that they are actually involved in the commission of the offence. Now, the legislation doesn't say they have to be the person holding the banner, but they have to be part of the wider group engaged in that activity. So I think, you know, traditional evidence gathering approaches, use of body-worn video, observations by officers, but that's why I said, you know, this is perhaps something that is a fairly resource-intensive thing to get it over the line correctly. Otherwise, like you've rightly said, it may be that the 1 or 2 activists within a group are relatively easy to demonstrate have committed offences, but then the broader group of 30 are much more difficult if you haven't collated evidence around the activities of the group as a whole and those individuals being part of that group.
No, I understand that, Mel. I wouldn't for 1 minute suggest that if any group who's protesting about women or pregnant people accessing that healthcare, you know, it's unfair in the group. But if individuals are, you know, preventing people, trying to stop people from accessing healthcare, then I do believe it shouldn't be left to the individual trying to access that healthcare to make the complaint. I believe that's a clear demonstration of harassment and intimidation. So that's point I'm making. And then secondly, you know, what constitutes graphic material and cause an offence? I mean, I've spoken to women who've been called murderers, who have had photographs of fetuses and babies that have died or been aborted. And some of these women weren't accessing termination of pregnancy, they were accessing fertility services and have had a history of miscarriage, and they found it horrific. Equally, I've spoken to women who have tried to access advice and support around an unwanted pregnancy, and they've all said, and indeed spoken to members of staff, that they feel harassed and everything else. So we've asked the Belfast Trust, we've asked different trusts what would be an example. So they have a duty of care to staff. They're very clear on that. PSNI are very clear in terms of what constitutes harassment. However, it's not clear, Mel, from what you're saying, of the role of the PSNI unless there's a complaint made. So someone has a right to assemble and they have a right to protest, but surely they don't have a right to harass or intimidate.
Yeah, and the PSNI definitely have a role. So if this bill was to be enacted as it is, or with some amendments, then as and when we have information of planned protest activity or information of spontaneous, then it certainly is the role of the PSNI to make sure that the law is upheld within the realms of the bill or any other applicable legislation that is available.
Oh, okay, so Mel, I'll just finish here, Caroline. What I think we need to do is certainly the proposer bill needs to have a conversation with yourselves and indeed legal advisors about ways in which we can be very explicit about what the intention here is, and then what potentially could be supporting the rights of people accessing those services. Because the issue here for us is that we don't want any ambiguity. I want people to be clear about what their responsibilities and indeed their rights are across the board. So thank you.
Thank you.
Thank you, Carol. And going then to Jerry. Carol, Jerry, go ahead, please.
Thanks, Chair. Thanks for the presentation. Just 2 points. In the document that we were shown or sent in our pack, point number 1 talks about seeking to influence someone is a fundamental aspect of protest, and removing that could be arguably removing their right to protest within the safe zone. I would think that is challenged in the sense that, okay, people who normally protest outside these centres are not allowed to in a small defined space, but by and large they can do it pretty much anywhere else in cities and towns right across the north. So I think, not from you, Melanie, but I think generally there's a narrative creeping in that somehow people engage in this kind of anti-choice protesting, and in some cases harassment, that they are somehow oppressed or marginalised, and I just don't think it's correct or it stands up to scrutiny. And I think this bill is quite limited, as others have said, in the scope. So you can respond to that if you want, but that's just a comment from me. And then a question, and apologies, I didn't hear some of the presentation, so you may have already addressed this, but on how many occasions on average are the PSNI calling out to medical centres where there are anti-abortion or anti-choice protesters on average year? On how many occasions are you called, and how many occasions would you just come out?
Yeah, just in relation to your first point, I'll just give a brief response. It was just to highlight that would be an area that may be subject to challenge. It wasn't a judgment from me at all. And actually the Ealing case that I referred to in 2020 did uphold that the establishment of a safe zone did not provide a blanket ban on protest and was human rights compliant. So it was an observation from me that would be an area that would be ground for challenge rather than a judgment from me at all. And then in relation to the second question, I wouldn't be able to give you accurate figures. I can get you some accurate figures if the committee felt that would be helpful. What I would say is my professional experience is that those kinds of protest activities tend to ebb and flow, sometimes around what kind of media interest there is in it at the time. So we may have periods where it's almost a daily, weekly occurrence, and we may have other periods where there's nothing for many months. So certainly when there was the clinic in Belfast, which I don't think is there anymore, there would generally be some kind of activity, protest activity there, and police deployment on a weekly basis. But anything further than that, and I'm aware that I think in the past couple of weeks there's been a police deployment to a hospital giving advisory services in, I think, Craigavon it was, in the past couple of weeks. But I wouldn't have the specifics on the numbers to hand, so I wouldn't want to mislead you. But certainly when there was the clinic in Belfast offering advisory services, there was usually at least one protest activity and police deployment every week, normally at the weekends.
Yeah, thanks for your answer. And if you could supply that information in terms of the average number of calls and responses and call outs that happens on average most years, I think that would be useful to form a real accurate narrative around the bill and the debate generally. And my experience is, I think you don't want to misquote you, but you used language to the effect of most of the protests have been sort of good-natured or a comment to that effect. I don't want to misquote you, but the fact that they're there outside healthcare clinics is distressing for people, even if they are, if it's holding a sign, an image, and obviously we've heard distressing cases of abuse and worse than that in terms of verbal language. So I think the fact that there's a presence there at all to stop or to try and pressure people from accessing health services, I think is a distress. But that's just a comment from me. Thanks.
And just to really sort of, I suppose, provide clarity, I wasn't saying that those protests were not distressing to individuals. I was more giving a judgment as to whether or not they were peaceful or non-peaceful from a policing perspective.
Yeah. Okay. Thanks.
Okay, Melanie, I'll check with the clerk if there's any other members indicating, but I have nothing else indicated there at present. There was, I suppose, one or two things I just wanted to touch base with you on. And I suppose, first of all, this is really by way of comment, is clearly from the evidence we have already heard, there are some very distressing incidents going on, which are impacting people personally and individually, but also impacting a range of people accessing a range of services and a range of staff working to provide those services. And as Jerry has mentioned there, we've heard some fairly harrowing examples of what that can look like in reality. In terms of reports coming back from your own officers, what type of incidents are being recorded or noted, or what kind of feedback are you receiving in terms of how some of these are some of the worst cases are unfolding on the ground?
Yeah, I think anything within this arena of pro-life, pro-choice narrative and protest, the vast majority of incidents that we see are either the display of graphic images, as really well articulated by Carol, the handing out of leaflets, and almost aggressive or bordering on aggressive tactics to try and influence people around choices and decision making. So certainly graphic imagery and banners are very, very common. Graphic narratives and articulation of fairly graphic things, some fairly unpleasant name causing and name calling and accusing behaviours, and the handing out of leaflets, but almost bordering up towards the quite aggressive end of that kind of spectrum. So quite confrontational, getting into people's personal space, and very much pushing their agenda to the point that and almost being, when people say no, I don't want to talk to you about that, a real reluctance for them to desist and back away. That would be probably how I would describe it.
Okay, thank you. And my understanding is, and I mentioned Scotland earlier, but actually I think it's maybe the Isle of Man that there's something in place. Canada has something similar, parts of Australia and parts of the United States. And I am aware that I believe in the south, they are developing safe zones. So there may be a way to draw upon, from a policing perspective, there may be a way to draw upon some of the learning from some of those other places. But I think given the contentious nature and given the evidence we've heard at committee, there is certainly a major issue here, and one that I don't think is going to be easily resolved, but can't be ignored either. But it is, and it will provide certainly particular difficulties for yourselves. So in light of that, I really do appreciate you coming this afternoon, Melanie, your presentation to committee, and your taking and dealing with members' questions there. It would be useful to get those additional pieces of information through, including, if you would, maybe send us through the other parts of law that where there could be a role to play, if you like, and the numbers that Jerry had asked for. But for now, I would like to wish you and your team a Happy New Year, and to thank you for coming to committee, and we can move on to our next session. Thank you.
Thank you very much.
Okay, members, so we're now moving on then to our second session in relation to this bill, and we are now going to take evidence again from the bill sponsor. So we're going to hear from Claire Bailey. I refer members to papers of tabs 3.1 to 3.3 of the pack. Included in the table pack there, members, there are copies of responses from some of the trusts in relation to additional costs incurred. And those responses are tab 3.4 to 3.7 of your table pack. So I'd now like to welcome to our meeting this afternoon Miss Claire Bailey, MLA. And Claire, I would like to check your sound first of all. Can you hear me okay?
I can hear and see you, Chair, very well. Hopefully you can do the same.
Yep. Hearing you there. It's a little bit low volume wise, but that could be just on my own settings. But I'm seeing and hearing you okay there, Claire. No problem with that. So Claire, do you want to go ahead and brief, and then we can go to members' questions?
Okay, Chair, I'll just shout in the hope that then you're picking me up okay. But if the sound drops, please just let me know and I'll try and sort it out. But I have Anya Grugan here with me as well, and just for social distancing, she can't be on camera, but she is very close by and ready to answer questions as they come up, and has been working very closely with me on this bill, if that's okay with the committee members.
Yep.
Great. Well, listen, I want to thank the committee for the sessions that you have had. The oral presentations I have felt have been very, very informative with this bill, and in particular, the session that was held when you had health trust staff and telling of their experiences and the impact on them. And I was particularly delighted when the Northern Ireland Human Rights Commission were with you and felt that the balance of competing rights under Articles 9, 10 and 11 had been met within this bill, and that this bill very clearly met the needs set out under CEDAW when they identified that women in Northern Ireland need to have safe access to healthcare. I have looked at the extensive written submissions as well and listened to the feedback coming through. And if it's okay with the committee, I'm happy to speak what I'm looking at potentially amending within the bill, and then happy to take any questions from yourselves from there. So a lot of stakeholder feedback and engagement has really focused on setting a minimum zone within the primary legislation rather than allowing this to be wholly set by the department. So I am more than happy, and I'm currently having discussions about drafting an amendment which does embed a minimum zone within the primary legislation, but then also gives the power to the department to potentially extend that zone if that minimum zone is not sufficient for the specific premises. So that is being looked at, that is being drafted, and I would be happy to share that with the committee once that's done. The other main issue that was coming up was sort of identifying what is meant by recording within the bill, and whether that needs to be further explained. So we're looking at adding an amendment to make sure that that includes video, audio, and note taking in particular within the bill. And I think it came up again in the session you've just had with the PSNI that under Section 7 of the bill that there are no powers for the police to either take names of people or seize property. But I am aware that under current legislation that the PSNI do have the powers to seize property or take names of people if an arrest is made. So, if the committee also feel that needs to be going a little further and maybe applies within these buffer zones, if they happen, these safe access zones, then I'm more than happy to have a look at that as well. Section 8 would be tidied up then if a minimum zone amendment was embedded within the legislation, and we will do that as well. And I know that the monitoring of the potential workings of any zone, if this bill was to pass under section 10, might need a minor amendment just to provide further clarity. But I'm content with section 10 as it is, but very, very willing to listen to further feedback from committee members if they have anything that they would like to raise. Anya, have I missed anything out? Oh yeah, sorry. The other thing to look at, sorry, was an amendment on the contained within the bill is the power for the department to revoke any potential safe zone unilaterally. So we will be looking at that to make it an operator-led decision rather than a departmental-led decision.
Okay, thank you, Claire. And in relation to the session that we've had with and I believe you were online throughout that session there with Melanie from the PSNA, are there any plans to engage with the PSNA or anyone else at this stage as a result of some of the sessions there's been? Are you planning any further engagements with any of the stakeholders?
Yeah, it's not actually the case that I haven't engaged with the PSNI. I have. I've met with the PSNI on a separate issue, just on a general meeting, as we do as MLAs, and the bill was discussed. And they did express that they would like to meet with me to discuss, the enforcement powers that could be coming through to the PSNI if this bill was passed. And that meeting was set up, and I have met with Superintendent Gillian Kearney back in November, specifically on this bill. Now, unfortunately, when that meeting happened, it took a while to set up, but the Superintendent Kearney hadn't actually read the bill when that meeting happened. So I did give her an oversight of the bill, and we did go into the enforcement powers and give her a general overview. And then again, following up from that meeting, I sent a copy of the bill and the AFM to the superintendent and expressed, to please continue talking to me, continue meeting with me, and I would be more than happy to meet anytime, as many times as possible. But I haven't heard anything back since.
Okay, thank you. And what about in relation to the department, Claire? Any further engagement or liaison with the department?
Yep, I have met with the department. I know that when you met with them, they did talk about the meeting that we did have. So I have since met with the department, most recently yesterday, and we were looking at the how we're going to move forward with this one. So again, their major concern, I suppose, or not concern, but their major issue was the setting of a minimum zone, maybe within the bill, that they would be keen to see that happen too. And we were talking about the potential of how that would work, and if a minimum zone was applied, would that be automatically applied to any service existing now or potentially in the future that may offer advice, guidance, and healthcare or counselling services on it? Would it automatically apply, or would a premises need to ask for a zone? I'm still of the persuasion that it should be operator and premises led rather than being automatic, because we don't know what the future is going to look like. Maybe I know that the commissioning of services is being worked on within the department at the minute, and I suppose until we have that commissioning of services, it's hard to see how this might apply if it was automatic, or any potential unintended consequences. So I am still discussing that, and I'm happy to do so, and again have more than happy to continue meeting with departmental officials, that when the amendments are drafted, we will be happy to go through those with the officials again as well.
Okay, thank you. I'll go there to members. I know we have an indication coming in from Carol McCullen. Carol, go ahead, please.
Hi, Claire. Hi, Anya. Thanks, Claire, for that. I'm glad that you've clarified that you did meet Gillian Kearney, and hopefully they're all across the your bill as well as the explanatory note. It's clear, even from listening to Melanie Jones, that there are laws that the PSNI can currently use, and I think where the gaps are, it definitely needs tightened up in terms of, I agree that the safe zone needs to be operator led, but the guidance that they can operate that safe zone and what they need to do to trigger it off, I think, is where the gap is, Claire. So I think we do need to tighten that up. And I also think in terms of revoking a safe zone, again, would need to come into that. So declaring and revocation for me would need clarity. And like yourselves, I do think that regardless of the potential of enforcement being subject to challenge, because we all expect that to happen, I would like to see, and maybe it's for us as a committee to write to the PSNI back to them, because the chair asked Melanie Jones to do for us, said to Melanie Jones that we would do that. But certainly in terms of what would constitute harassment, because the onus doesn't need to be on the person accessing the healthcare. I mean, if the PSNI are called to a healthcare setting, and it's clearly the people feel harassed or intimidated or perhaps even impeded, then there's current legislation that they can use. So what we need to find out is what would they do in the event of graphic materials, and you said, video recording, audio and note taking. So I think that would need clarified as well. And I don't know how that clarification is going to be sought by yourselves, Claire, but certainly in terms of the committee, I would like to see us asking for that. And then the final thing is, we've also asked for instances elsewhere. I mean, Newry is the case in point that wasn't mentioned. But even just, like family planning clinics and things like that, there was protest outside there. But some of the health and social care staff, despite what the trusts have said, feel that the support and the legislation needs to be very clear. And so if there's anything else that we can tighten up, or you can tighten up in advance of legislation being brought forward, and there's anything that we can do in terms of asking additional questions, we would welcome that, because we don't want anyone, first of all, the right to assembly and the right to protest is accepted, but certainly the right to access health care without intimidation or harassment needs to be accepted also. So I'll just leave it there, Chair.
Okay, thank you. And I will just check with the clerk as well if there's any other members wishing to come in with any questions at this point in time. I suppose, just kind of building upon what Carol has said there, I suppose the fear would be, or the concern would be, that similarly to the harassment, where it has to be 2 incidents, that the recording would similarly, it would be passed around the group or whatever to facilitate the ongoing nature, but to thwart any attempt to prevent that type of behaviour where it crosses the line into. And again, that's something that we've been clear about from the start. I think we all recognise and respect people's right to protest and to have a view and express a view and all of that. What we're talking about here is very particularly around the evidence we have heard around the extent and the impact of some of this. So, okay, I just want to check with you, Clerk, then.
No, Chair, no further indications from members.
So, okay, well then what I'm going to do, Claire, is there anything further you want to say in regards to closing?
Yeah, thank you, Chair. And again, I just want to reiterate, if members, I know that there's been a lot of discussion, and rightly so, on the impact of any potential protest in the future, or if this bill was enacted, how it would impact on the right to protest, but and a lot of discussion has happened, and we've heard it again in the last session too, about, the right to hold maybe distasteful views or conflicting views. That's not what this bill is about. This is not about conflicting views and whose view maybe supersedes or is more than anybody else's, because the right to hold views, regardless of what they are, does not override the right to access safely healthcare, and that is stipulated under Article 8, and that's what this bill seeks to do. So rather than restricting a person's right to protest or hold views, and I think Jerry Carroll has been very succinct in his question in there as well, this does not restrict anybody. They can do it anywhere else apart from in a safe zone, because within this safe zone we have a legal obligation under human rights to uphold women's right to access safe healthcare. and that is not being upheld at the minute. And that's exactly why CEDAW identified the problem in their inquiry, and that's exactly why the Northern Ireland Human Rights Commission came and expressed in their opinion this bill sought that balance of competing rights. So the competing rights under the Human Rights Act have been met under this bill, and that is absolutely not in conflict with anybody's right to hold an opinion or a view or express that. That is not curtailed within this bill. But what this bill does is seeks to ensure safe access, unimpeded, to health care.
Okay, thank you, Claire, and thank you for assisting the committee with their ongoing consideration and scrutiny of this bill. And we can let you go there at that. I will just members. So we have agreed there that we will seek that additional information. And also, what I will propose now is we will take a short break. We'll take a short break now before we resume with our consideration of the autism bill. So maybe a 10-minute break, and we'll come back at 13:40, please. So a 12-minute break there. Thank you, members. Are we back online, Clerk?
That's us back online now, Chair. I'm going to bring the rest of the members up now as well.
Thank you. Okay, I'll just take an indication from you, Clerk, when you're ready for us to start.
Yes, Chair. Ready to go when you are.
Okay, thank you, and thank you, members. So we're now resuming in public session. Just to say, following on from the last session around the safe access zones, we will then be moving on Thursday to our informal deliberations on that and starting to consider what amendments might be indicated. So just for information for members, just to focus your minds on that, that's where we're at as far as that bill goes. So we're now going to move to the Autism Amendment Bill, the clause-by-clause consideration. This will be the committee's formal clause-by-clause consideration of the Autism Amendment Bill. I refer members to the Clerk's memo at tab 4.1 of the pack. A response from the trusts following their briefing is at tab 4.5 of your table pack there. So do members wish to declare an interest at this point? Yes, Pam?
Thanks, Chair. Yes, just to officially declare an interest as the bill sponsor, and to say that if there are any issues arising even at this stage, if the clerk wants to write to me formally as bill sponsor, I'm happy to respond.
Okay, thank you, Pam. And I don't see any other indications from members then. Okay. So members, before we go to the clause-by-clause bill, the bill clerks have provided revised amendments based on the discussions that we had on the 16th of December. At tab 4.4, there's a copy of those draft amendments. The first amendment C includes housing in the list as per the committee's request. If members recall, we discussed that at some length and we concluded that we would like housing to be included. Are members content with this amendment? Yeah, members content, thank you. Also included then were two different options for the independence of the reviewer. This is something that we've discussed again in some detail. The first option states that the reviewer must not be a person employed by a department. And the second option states that also, but it adds that the reviewer is not subject to the direction or control of departments here in the North, apart from the requirement to pay the reviewer's expenses and allowances. So the bill clerks are available if any further clarity is required, and if members want to speak to the bill clerks around that, we will need to move into closed session to do that. But do members have any view as to which of the two? Members seem to be content with first of all the housing one. We'll set that to one side. But in terms of the independence, are members content with the amendment as drafted? The first part of it, Deborah, go ahead.
Thank you, Chair. I think I would support.
Okay, can I just check, Clerk? Have we lost Deborah, or have you lost my feed?
I think we've lost Deborah. She's frozen there, so. We'll try and get her back on.
Okay, and in the meantime, while we're trying to get Deborah back online, do any other members wish to indicate or their preference in terms of those two options or thoughts on them? No, we don't have that. So listen, we'll give another minute or two because we've found it's easier to get people back online if we continue with the session. Deborah, are you back online? Deborah, can you hear me now?
Sorry, I don't know what happened there. Everything just dropped out. I would support. I would support option 2. That has been drafted there. You said there that we might have to go into closed session. So if it makes it easier, I could wait maybe till we are in closed session because I would like some clarity just from clerks. In terms of that option. Or if you want to get asked now.
No, if you want to take some clarity from the bill clerks, then we'll go into closed session. We'll take that piece of work and then we'll come back to the clause by clause. So, clerk, could I ask you to put us into closed session and to bring up the bill clerks to take a steer from them for Deborah?
No problem, Chair. I'll just take a wee minute just to take us offline on all the streams, but I'll give you a wee shout once we're confirmed that we're offline and we can bring Catherine and Philip.
Yeah, so if members can just be aware that until the clerk indicates, we will be continuing online, and then we'll be coming off after his indication. Thank you.
That's us in the open session again, Chair.
Okay, thank you, Clerk, and thank you, members. So we will resume then. And members, I will now go to the clause by clause consideration and put each of them in turn formally to the committee for agreement. So first of all, in terms of clause 1, the autism strategy and data, is the committee content with clause 1 as drafted? Yeah, committee content, thank you. The committee is content with clause 1 as drafted. Moving on to clause 2, members, additional components of the autism strategy. There are 4 previously agreed committee amendments to this clause. One is to clause 2, page 1, line 17, after autism, insert support and. Are members content with this amendment? Content, thank you. The second amendment then in that is in clause 2 on page 2, line 7, and it says that at end we will insert brackets, CA, close brackets, physical health. Are members content? Thank you. Moving on then to point 3 on that clause. In terms of clause 2, this is on page 2 at line 9, that we would at the end of brackets F, we would add in or insert housing. Members content? Thank you. And then are members content with this amendment, clause 2, page 2, line 9, at the end that we insert after 4E, the autism strategy must set out how the department will reduce waiting times for autism assessment and treatment services provided by HSC trusts. Are members content with this amendment? Yeah, thank you. So then, members, I'm going to put the question, is the committee content with clause 2 as amended? Yeah, committee content. The committee is content with clause 2 as amended. Thank you, members. So moving on then, members, to clause 3, which is to do with the methodology of the autism strategy. And there have been 2 previously agreed committee amendments to the clause. The first one is clause 3, page 2, line 17, where we have agreed that we would like to, after multidisciplinary, insert and cross-departmental. Are members content with that amendment? Yeah, thank you. And then clause 3, page 2, line 18, we had agreed that we would prefer to leave out subsection 4 and insert instead for subsection 4, the autism strategy must set out how consistency of practice is to be achieved across HSC trusts and across A, HSE trusts, and B, education services. So members content? Yeah, thank you, members. So I therefore put the question on clause 3, members. Is the committee content with clause 3 as amended?
Yeah.
Yeah, committee content. Thank you. The committee is content with clause 3 as amended. Thank you. Moving on then to clause 4, annual autism funding reports. So I'm going straight to, there's no amendments indicated here, so I'm going straight to the question. Is the committee content with clause 4 as drafted? Yeah, committee content. The committee is content with clause 4 as drafted. Thank you. Clause 5, autism reviewer. So there is one previously agreed committee amendment to the clause, and that was that amendment option 2, that clause option 2 as we have agreed there previously. At clause 5, page 3, line 16, at the end we would insert 1A. The autism reviewer must not be a person employed by a Northern Ireland department. 1B, the autism reviewer is not subject to the direction or control of the Northern Ireland departments. And 1C, but this is subject to the requirement under this section for the department to pay the autism reviewer's expenses and allowances. Are members content with the amendment? Yeah. So therefore I put the question in relation to the clause. Is the committee content with clause 5 as amended? Yeah, thank you. The committee is content with clause 5 as amended. Moving on to clauses 6 to 8, which include the interpretation, the commencement, and the short title. Is the committee, and I will go straight to the question here again, there were no amendments indicated here. Is the committee content with clause 6 as drafted? Yeah, thank you, members. The committee is content with clause 6 as drafted. In terms of commencement, is the committee content with clause 7 as drafted? Yeah, the committee is content with clause 7 as drafted. Thank you, members. And the short title, and I've again put the question, is the committee content with clause 8 as drafted? Yeah, thank you. So the committee is content with clause 8 as drafted. So moving on, members, then to the long title, and I will put the question, is the committee content with the long title of the bill? Yeah, thank you. The committee is content with the long title as drafted. Members, that completes our formal clause by clause consideration of the bill. We will now move into the closed session to look at our consideration of the draft report. So I will just go back to the clerk there to see, clerk, can you take us out of open and go into closed session for the consideration of the draft report? Thank you.